All right, let's dive right into this explainer on Canada's incredibly unique dual legal system and what it actually means for everyday business. If you're studying business, management, or honestly just want to understand the invisible rules that govern our society, you are definitely in the right place. We're going to break down how a single country operates under two completely different legal traditions, and we'll do it by looking at a tale of two cities.
Here is our roadmap for today. 1. Canada's dual legal system. 2. The purpose of law. 3. The common law tradition. 4. The civil law tradition. 5. Bejuralism and the courts. And finally, 6. The supreme law. Let's get right into it.
Section 1. Canada's dual legal system.
Let's strip away all the dense academic jargon for a second and look at this through the eyes of an entrepreneur. Imagine two small business owners, one setting up shop in Calgary, Alberta, and the other is in Montreal, Quebec. They open their doors on the exact same day. They both hire employees, sign vendor contracts, buy property, and yeah, they both pay taxes. Now, at first glance, you'd probably assume the laws governing their day-to-day operations would be identical, right? I mean, they both live in Canada. But beneath the surface, they are actually playing by two entirely different rulebooks.
It's a literal split right across the country. Our Calgary owner operates primarily under the English common law system, while the Montreal owner navigates their private matters using the French civil law system. This makes Canada one of the very few countries in the entire world that officially runs two major legal traditions right side by side. It's a brilliant, living compromise that shapes literally everything from a simple business contract to buying a piece of property.
Moving on to Section 2. The purpose of law. You know, the law isn't just a giant list of penalties. It's really the invisible infrastructure of our entire society. Think of it like this. It maintains social order, essentially preventing chaos so businesses can actually operate with confidence. It gives us a fair system for resolving disputes, like say, if a landlord and a tenant have a major disagreement. It protects fundamental human rights, secures property ownership so your hard-earned assets can't just be snatched away, and it regulates business activities to make sure commercial practices are fair and contracts are actually enforceable. Without this underlying structure, doing business for either of our entrepreneurs would be a complete and total guessing game.
Section 3. The common law tradition. Okay, so the absolute bedrock of the common law system is a Latin term called stare decisis, and that simply translates to stand by decided matters. Basically, in the common law tradition, the law is largely developed over time through judicial decisions. When a judge makes a ruling, boom, that ruling becomes a precedent. Future courts will then look back at that precedent and follow it to maintain a predictable and consistent legal environment. So judges are literally helping to shape the law as society evolves.
Let's look at how precedent actually works for our Calgary business owner. Say a court in Alberta decides that employers absolutely must provide a very specific, brand new type of workplace safety gear. Well, because of stare decisis, future courts facing similar cases will adopt that exact same rule. This system is wonderfully flexible, you know? It adapts gradually as our society changes. A great example is modern privacy laws regarding technology. They've evolved heavily through these gradual court interpretations. But it can also be pretty complex and expensive, mostly because lawyers have to dig through hundreds of past cases just to build a solid argument.
All right, Section 4, the civil law tradition. Now, over in Montreal, instead of digging through a mountain of dusty old court cases to figure out the rules, civil law relies on comprehensive, meticulously organized written rulebooks. For our Montreal business owner, this is known as the Civil Code of Quebec. It dictates all those private legal relationships, things like contracts, property rights, and civil liability. What's cool is that citizens can actually read the legal rules directly for themselves. In this system, previous court cases might be influential, sure, but they aren't strictly binding like they are in Calgary. A judge's main job here is simply to interpret and apply that written code, not to invent new law.
When you compare them side by side, the divide is fascinating. Common law is built entirely on precedent, whereas civil law is based on those written codes. In common law, judges actively shape the law, but in civil law, it's the legislatures writing the rules. So common law tends to be flexible and constantly evolving, while civil law is highly structured, codified, and super predictable. It really is an incredible contrast in how two totally different societies approach fairness and order.
Section 5. Bejuralism and the courts. So what do we call this? We call it bejuralism. It's the official coexistence of two completely different legal systems living under one national roof. For Canada, this setup beautifully preserves Quebec's unique French legal heritage while simultaneously accommodating the British common law traditions of the rest of the country. It's a system that truly respects cultural diversity and reflects Canada's deep, complex historical roots.
But here is where it all finally comes together. Despite having totally different systems for private law, both our Calgary and Montreal business owners actually navigate the exact same structural hierarchy of courts. Whether it's a minor squabble in the provincial courts, a major dispute in the superior courts, or a review up in the courts of appeal, both pathways eventually ascend to the exact same destination, the Supreme Court of Canada. As the highest court in the land, its decisions influence all Canadian courts, acting as the ultimate bridge between both systems.
And finally, Section 6, the Supreme Law.
Now, while private matters like business contracts are split, public and federal matters are totally unified across the board. Constitutional law, which established Canada's federal system in the first place, is the supreme law of the land. Literally, no law can violate it. Nestled right within that is the Canadian Charter of Rights and Freedoms, which guarantees equality and freedom of expression for everyone. On top of that, criminal law is entirely federal. There is one uniform criminal code across the whole country to deter crime and keep society safe. So whether you're standing in Alberta or Quebec, a crime is a crime and the constitutional rights you hold are exactly the same.
Canada's bi-jural framework proves that diversity in thought and tradition can actually build an incredibly robust, highly functioning society. So I want to leave you with this final thought. Could a dual system effectively manage other complex, culturally diverse areas of our global society? Let that sink in. Thank you so much for watching this explainer. If you found this breakdown helpful, please like the video and subscribe to the channel so we can keep bringing you clear, structured insights into the systems that run our world. Catch you next time.